Last up is Catherine Rogers to talk about Arbiter Intelligence.
When high-stakes international business deals go bad, parties don't go to court. They go to arbitration. Why? Because parties in international disputes don't want some foreign national court judge deciding their case. They want to be able to pick their own judges. Excuse me. They want to pick their own judges. And in the system called international arbitration, they can do that. That's right. In international arbitration, parties pick the arbitrators who decide which of the parties wins hundreds of millions, if not billions of dollars, and which party loses it all. So when everything rides on picking the right arbitrator, parties naturally engage in a sort of informational arms race to find out everything they can about these arbitrators. And that brings us to the problem. International arbitration is a secret. That means that parties, when they need this information about arbitrators, can't just look it up. Instead, they have to call around and hope that they can find someone who has this information, quote, in their minds. Now, so picking the right arbitrator is the single most important decision, strategic decision, in these high-stakes, multi-million-dollar, multi-billion-dollar cases. But even in our modern, data-driven world, the parties still rely on 19th century technology, the telephone. This environment is every investor's dream, a super high-stakes, price inelastic market that remains frozen in time and in desperate need of a technological upgrade. Enter Arbitrator Intelligence. We've broken through the conundrum of arbitration secrecy by collecting data through a confidential online survey. We then analyze that data to produce individual reports on arbitrators that can be sold at the click of a button. Here's an example of one of our reports on a very famous arbitrator named Roque Caivano from Argentina. Now, some other companies have tried to crack the code as well, but of all these different companies, using Roque Caivano again as an example, none of them have come up with any information about him from these secret arbitrations, except for one, which actually conducts on confidential interviews by telephone. So this is a market that's clearly in need of a disruptive innovation, and the question then becomes, how can that disruption be monetized? So let's go through some of the math. With single-use reports on individual arbitrators, we start with about 5,000 estimated arbitrations per year, and at least 2 parties per case. Each party will typically research about 5 arbitrators, which means about 10 reports per case, and at an average price of $5,000 a report, the numbers add up fast. Now, we spent years developing our survey and then collecting data. So we're ready to start selling reports that we have, by January of 2020. And from there, similar to a SaaS-based model, we can scale quickly to become profitable.
I'm going to have to stop you. Sorry, your time is up.
Oh, thank you.
And we're now open for questions,
Okay.
So is your target customer multinational companies that are potentially exposed to arbitration?
Yes, so we have, there are basically 2 categories, law firms and corporations, and usually multinational, but also smaller and medium-sized entities.
Wouldn't most of those already have arbitrators that they like to use in all the usual places?
Yeah, so parties cannot legally continue to use the same arbitrator. There's limitations on how frequently you can appoint the same arbitrator, number 1. Number 2, the data in our reports will become stale, so they have to, both as a technological matter, because they'll have limited use of our reports, and as an ongoing matter, they'll have to repurchase them because the data in them will become stale. And the importance of having current data is so important that they wouldn't be able to take the risk, essentially, of using an outdated report.
How does your plan stay current? Because you won't be selling just the old information. You'll constantly need to be updating as you move along.
Actually, that's our biggest challenge. We don't think that selling these reports will be difficult. The market is so hungry for this information. It's really a desperate need. The challenge will be generating the data. And so the way we're going to bring it to market is through membership models. And membership pricing will be dramatically lower than people who are not members, and membership will require ongoing contribution of data to help build our database.
Who do you see so first of all, you have to motivate people to give you the information, and it seems that there's a number of different parties that may want to give you the information. The companies that participate, the lawyers that participate. How do you see motivating each of them to give you information, and why would they do that?
So we're developing a series of sort of carrots and sticks to tie the sales of the reports with the generation of the data. So membership models will be primarily targeted at law firms, because they are the ones that end up having the most cases, but we're hoping that corporations will essentially put pressure on their law firms by adding, and to incentivize that, will add a sort of stacked discounting model, so that corporations, for example, if Chevron encourages it's both a member and its law firms are a member, the big discount will go to the law firms, but an added discount will come if Chevron is also a member.
So will you have a way to filter arbitrators by their field of expertise? Let's say there's a mine in Brazil that's contaminating or accused of contaminating groundwater. Will there be arbitrators that have knowledge of water remediation technology or issues?
Yeah, that's a good question. So our questionnaire actually collects data based on the cases that they sit in, and it can be filtered or analyzed based on any number of variables, including, of course, the expertise of the arbitrators, the size of the case, the region, the legal rules that apply, or the arbitral institution, which is the entity that administers the arbitration.
And you said you'll be ready to go to market in January 2020, so relatively soon. What's your marketing strategy? Are you going to be contacting law firms worldwide, or people contacting you yet?
Yeah, so we're already in contact worldwide with law firms. We've existed for about 7 years, and in the process of creating the questionnaire, we went in-house to hundreds of different law firms and corporations. So there was a creation of the questionnaire, actually, that was a lot of what would be called now customer discovery, to give us the data that we need to be able to create the reports. We still, in the next few months, are doing customer discovery with our sample reports, and that discovery focuses on things like pricing, presentation of the data, and some of those more softer questions. But we do intend to have a number of initial reports ready in January, building each month, and again, coordinated with an aggressive strategy of building the data.
Catherine, it seems like you're selling these reports, but it also seems like you'll have a database of arbitrators. Are you going to help people decide what arbitrators they want to report on? Or is it they've got to say, hey, these are the arbitrators that we'd like to understand?
Yeah, so the implications for having this kind of data is pretty radical in a system that's so closed and opaque. Initially, we're starting with people develop a list of arbitrators they want information on, and we can give them that information. Eventually, with enough data, we should be able to search our database to identify based on industry, based on also procedural strategies. Like, for example, we want a document production arbitrator who's going to grant us lots of document production or injunctive relief. And you can search for the procedural mechanisms, the arbitrators that have an experienced track record in the procedures and the strategies you want. So yes, eventually we'll be able to provide, to help people identify arbitrators and other applications like doing case-based research.
And your revenue model is a subscription fee plus a fee per arbitrator selected?
So no, the primary revenue model, we might eventually have a charge for memberships, but our main source of income is going to be the sale of the reports. And the cost of the reports will grow over time as we have more data. Interestingly enough, and I'll close on this, in the over 500 people I talked to, every single time I asked, if we had even only one questionnaire, would you pay for a report based on one questionnaire, one response? And no one ever said no, because that's how desperate they are for this data.
Thank you very much.